think the submissions I'm going to make are no attack on the ruling in any way. But as the chairperson and the panel will know, I'm new in the matter, but clients keep looking at what is actually in the public interest to do and what is practicable. And one of the issues when we must determine to the panel as to which issue must be done public and which one must be done in camera, it becomes difficult, not just for counsel, it can become burdensome even for the witnesses who may have to be cross-examined, re-examined twice because the issues are intertwined. And so when looking at those practicalities and knowing that without any attack on the ruling, it's as good as it was sought, this panel is permitted to determine its procedures. And our view, having looked at the practicalities, is that, and what exactly is in the interest of the public and the judiciary, our submission is that the matter be ventilated publicly if the panel is so inclined. Thank you, Judge Torres. I appreciate that. I appreciate it. I don't even want to use the excuse that I was briefed the day before Christmas. I'm new in the matter. It's no sufficient reason. But you know, preparation for a hearing sometimes is the one that reveals certain things that may not assist in determining a matter. And I think this was birthed by that kind of preparation, apart from the fact that I was new and I have a different perspective about how practical this would be. So while I apologize for my client that it was raised and my attorneys, but it was not because of any shoddiness. It was because in preparation in getting to deal with this use, you certainly have to take into account the prejudices, the impracticalities of doing things. And lastly, I'm not the determinant of this, and you also have to consider what exactly is in the interest of the judiciary. Is it when something is hidden and therefore there is speculation out there about it, or is to open it up for people to see what it is that is being dealt with so that they can trust the process? So it was a combination of all of those, but really about why it was late, I think it's partly because of the intricacies of preparing for something that is like this, that's emotional, that's detailed, that no one knows which is the right way to do them. And my late involvement, which came with another perspective that, well, I don't think I can cross-examine to and fro, in and out, public and not public. Those are my submissions.
Thank you, Mr. Sukakane.
Thank you.
This is the inaugural instance in which the tribunal has been established to investigate allegations of sexual harassment against a sitting judge of President of the High Court. This has never been done before. This tribunal was established pursuant to the Judicial Service Commission Act, following the ruling by a Judicial Conduct Committee appointed by the former Chief Justice. The then Chief Justice established the JCC in terms of Sections 8, 9, and 10 of the Judicial Services Commission Act. The JCC then conducted a process in terms of Section 16.4 of the JSC Act to determine whether a prima facie case of misconduct had been established against Judge President Mbenenge, and to further determine if that conduct amounts to gross misconduct. Having concluded its process, the JCC then found that the complaint establishes a prima facie case which, if substantiated, is likely to result in a finding of gross misconduct. It therefore recommended that this tribunal be established in terms of Section 19 of the Act. In accordance with Section 25(1) and Section 26 of the JSC Act, and as mandated by Chapter 3 of the Act, this tribunal has been established with the responsibility of regulating these proceedings and conducting an inquiry into the allegations of misconduct, gross misconduct, by 1, collecting evidence, 2, conducting a formal hearing, 3, making findings of fact, and 4, making a determination on the merits of the allegations. The complaint before this tribunal is that Judge President Mbenenge sexually harassed the complainant and that this constitutes gross misconduct. The complainant asserts that she endured sexual harassment in multiple forms, including the receipt of sexually suggestive messages through social media, and that will be on the platform WhatsApp, inappropriate comments and gestures regarding her physical appearance made in person while at court, and a specific incident within the Judge President's office during which he made sexual remarks and gestures of a similarly inappropriate nature. The Judge President has already admitted to engaging with the complainant on social media platforms in a way which was clearly sexual and clearly inappropriate for the most senior judge in the division. Furthermore, it is important to note that the complainant is among the most junior members of the court administration. The inherent power imbalance between the complainant and the Judge President is a critical factor in understanding and evaluating the evidence to be presented during these proceedings. The evidence before the tribunal. The complainant will provide testimony before this tribunal which will establish that the engagement between herself and the Judge President occurred without her consent. Her account will clearly demonstrate that the interaction was not flirtatious but rather was unwanted by her. She will testify that she tried to make this clear to the Judge President on several occasions, but the Judge President intentionally disregarded her boundaries and persisted in his pursuit of a sexual relationship with her. It is the responsibility of this tribunal to fully comprehend the complexities surrounding sexual harassment and sexual violence, particularly in the workplace, and to evaluate these claims through that nuanced lens. The tribunal must take into account the significant power dynamics at play in this case. As a Judge President, he holds substantial influence over the entire judiciary in the Eastern Cape. Despite this power, the Judge President never sought to establish whether the complainant was willing to engage in a consensual relationship. Instead, the complainant will testify that when she requested a meeting with him to address his inappropriate behavior, she ultimately withdrew her request after the Judge President reiterated his desire for intimacy, even though she had explicitly rejected such advances on more than one occasion. It is crucial for the tribunal to recognize that sexual harassment is not a neatly defined or straightforward complaint. It will be like no other complaint a tribunal of this nature has had to investigate, as sexual harassment and sexual violence often happen in secret, especially in the workplace. This secrecy often affords perpetrators a sense of impunity and casts doubt on the credibility of complainants when they eventually come forward. During the course of these proceedings, several witnesses will be called to testify. These may include current judges from the Eastern Cape Judiciary. While these witnesses may testify what they heard or were informed of, none will be able to offer direct knowledge of whether the alleged sexual harassment took place.